An unexamined life is not worth living. Hello everyone, welcome to UPSC Talks from Lukman IAS. My name is Jahidul, and in this episode today, we are going to discuss about a case with reference to the freedom of speech and expression. As you might have all read, that recently the Bombay High Court has delivered a judgment, and this judgment was related to the IT rules of 2021. And in this discussion, we are going to, go into details to understand about various aspects related to this particular thing. All right. So, as we have discussed that the Bombay High Court has delivered a decision related to the IT rules. So, what was that IT rule? Technically, this IT rule is known as Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021. So, an amendment to this rule was brought by the Union government, and the Bombay High Court has finally delivered a judgment, and in that judgment, the Bombay High Court has held this amendment to be unconstitutional. But on what grounds the Bombay High Court has, told that this particular amendment to the IT rules was unconstitutional? So today we are going to look into that aspect. Okay. So now the question is that why the Union government has come up with an amendment in the first place. What was the purpose of bringing an amendment to the IT rules? The purpose of the government was to basically identify any misleading information related to the Union government. If any, let's say, information which is circulating on the internet via multiple platforms, if that information is found to be untrue, if that information is found to be misleading, if that information is found to be false, so in that case, the Union government wanted to empower itself so that it can identify those misleading information and it can potentially take a step to take down those information from the internet. So for that purpose, they have brought this particular IT rules amendment, amendment to the IT rules. However, is this particular issue so simple? No, because this also involved the fundamental rights of citizens. How? We are going to discuss about the issue. Basically, the amendment to the IT rules had some bearing on the fundamental rights of citizens which pertain to the freedom of speech and expression. So we are going to discuss about what is freedom of speech and expression. So when we talk about freedom of speech and expression, they are inherent rights to a human being. And it is universally accepted, it is universally recognized under the Universal Declaration of Human Rights under Article 19. And also it is recognized under the International Covenant on Civil and Political Rights. Alright. And even if we talk about the Constitution of India, in the Constitution of India under fundamental rights, we have Article 19 of the Constitution of India that talks about the freedom of speech and expression. And freedom of speech and expression are protected, right, in case of Indian citizens. So now the question is how this particular IT rules, right, violated the freedom of speech and expression. See, when we talk about expressing oneself, right, one can express oneself through verbal means by communicating, or through written means, or through any platform, right, or in any medium, right? So irrespective of the medium through which the information is passing on, right, the citizens of India has an inherent right, okay, fundamental right to express their views, to express their opinion. And the courts have recognized this particular thing, okay. The Bombay High Court in this particular case have recognized it so that the citizens have fundamental right, and this particular amendment is actually violating the fundamental rights of the citizens. So I would like to bring your notice to one anecdote. Anecdote means a story that hails from Athens. So long back, you might have heard about the philosopher, thinker Socrates, okay. Socrates was a person who was a philosopher, and he truly believed in, open discussion with people. so that ideas can be shared. Okay, he also believed in dialectics. Dialectics means someone is saying something which is thesis. There can be, let's say, like, contrary views to this, which is known as antithesis. And then when those contrary views are also accommodated, which is known as synthesis. So thesis, antithesis and synthesis, they are important for having proper dialogue with people. So Socrates believed that, like, there should be inherent right to people to discuss about multiple things that are happening in the society, and even people should have the freedom to criticize the government if they are, like, doing anything wrong. But like Socrates have been tried in, let's say, Athens, and Socrates had defended himself with a lot of viewpoints. However, ultimately the state has held him to be, culprit in this particular case, and the state has told him to drink poison. So Socrates have drank the poison, but still he, he was adamant, he was, very much sure about what he believed. So he believed in his intellectual integrity. All right. So apart from this, when we talk about, let's say, are there any reasonable restrictions? Are there any restrictions on exercising the freedom of speech and expression? Yes, we do have certain reasonable restrictions, and these restrictions arise from multiple factors. Some of these restrictions are even mentioned in the Constitution of India. One should not interfere with any of these things like security of a state, friendly relations with foreign states, public order, decency or morality, or whatever someone is speaking, it should not amount to contempt of court. Okay, then defamation, like incitement to an offense. These are the things that are basically reasonable restrictions on freedom of speech and expression. Apart from this, every Indian citizen is allowed to speak freely, right, his mind. Even like they can criticize the government, they can, they can hold the government accountable for their actions or like actions or omissions. All right. Now, if we talk about this Bombay High Court ruling, so who were the parties to it? On one side, there were petitioners. Petitioners included Kunal Kamra, and apart from this, petitioners included, let's say, like Association for Democratic Reforms, ADR, and many other parties. Okay, so these parties petitioned in the Bombay High Court, and they have said that the IT amendment rules are actually violating the fundamental rights of the citizens. Okay, so they said that the state is trying to be a judge in its own case. How? The state is identifying which information is false, misleading, or misinformation, state it itself taking actions related to it. Okay, so that's how states are acting as a judge in its own case. And what was the response from the side of the government? Okay, so on the other side, the respondents were the governments. So government has said two important points. One point, they said that this particular act, the IT rules, is not coercive. The government of India had established a fact check unit under the Press Information Bureau, and this fact check unit would identify which information on the internet is, let's say, like misleading or false information or misinformation related to the government. And so they could tell the platforms like Facebook, X or Twitter and Instagram, WhatsApp, etc., to take down that information from their platform. Okay. However, the intermediaries were not compelled to act accordingly. They can also, let's say, represent their own views. Okay, so this was one opinion from the government. The second opinion from the government was that no person enjoyed, let's say, like, license to spread false or misinformation about the government. So these were the 2 points from the side of the government. Okay, but the thing is, like, now the concern comes, the question comes related to these intermediaries. Intermediaries means like these companies, Facebook, Twitter or X, then Instagram, any other social media platforms. So when we talk about these social media platforms, they enjoy something which is known as safe harbor. Okay, what? Safe harbor. What do we mean by safe harbor? I'm going to explain about it. So basically under section 79, okay, of the IT Act. So in that section, there was an exemption for these companies that were just acting as, let's say, like, host, like they were acting as host and they were transmitting the information, but the information itself was not generated by these companies. This information was user generated information. Okay. So these companies were exempted from any liability, right, of the information that is being propagated on these, like platforms, provided that these companies observe due diligence in their own action according to this particular law. Okay. So these intermediaries were released from liability for any third party information that is hosted on their platform, right? So now when we talk about, let's say, what the Bombay High Court has done, basically initially there were two judge bench was established, and these judges have given a splitting opinion. So they have given, one judge has given opinion in favor of the petitioners, other judge has given opinion in favor of respondents. So like, it was a kind of tie. Okay, so a decisive decision was not taken. Later on, the Chief Justice of the Bombay High Court has given this particular case to another judge, so that the third judge can look into this aspect and then can act as a tiebreaker. And this third judge was Justice A.S. Chandurkar. And this justice, has looked into multiple aspects. He has looked into multiple aspects, what the petitioners have to say, what the respondents have to say. And finally, he has held that this IT rule is unconstitutional because it violated the fundamental right under Article 19 of the Constitution of India. All right. So this was the case. Thank you so much for watching this video. I hope you have a good day ahead. Thank you.